Civil Procedure Code, Unit 2. So the first concept in Unit 2 is Section 26, Institution of Suits. So every suit shall be instituted by the presentation of a plaint, or in such other manner as may be prescribed. In every plaint, facts shall be proved by affidavit. So suit is instituted by filing a plaint. It is governed by Order 4, that suit is instituted by presenting a plaint in a duplicate. So along with the plaint, a duplicate of a plaint has to be filed, and the plaint should comply with the rules of Order 6 and 7. Case law. Secretary of State versus Kundan Singh. A proceeding which does not commence with a plaint is not a suit. So a proceeding should always commence with a plaint. Next concept is summons. Order 5 with section 27 to 32. So what do you mean by summon? Summon is a document which is issued by court calling a person to attend before court for a specific purpose. So after filing of the plaint, the court issues a summons to defendant so that the defendant may make his appearance in the court. Court compels the attendance. Section 32. How court compels the attendance of a person to whom summons is issued? If the person is absconding summons, then the court may force the summons by issuing arrest warrant against that person, or attaching and selling his property, imposing fine up to ₹5,000, or by ordering to furnish security in a default civil prison. So this is how the court compels attendance of a person. Order 5. So Order 5 is divided into two parts. First is issue of summons, and the next is modes of service of summons. So in issue of summons from Rule 1 to 8, it has the contents of a summon, what a summon should contain. So the contents of summon, the summon should contain reasons for sending it, then a sign of a judge and the seal of the court, then a specified date for appearance of the defendant, and a copy of plaint should be present in a summon, and that all this document should be sent to the defendant to make his appearance. The most important concept, modes of service of summons, Rule 9 to 30. It has been asked for 10 marks. So there are basically 5 principal modes. The first is personal or direct service, Rule 10 to 16 and 18. So if practicable, served to defendant or his agent, the summons may be directly given to the defendant or the agent of the defendant. And if a defendant is absent and he has no agent, then to any adult male or female member of the family who is residing in his house, to them the summons can be served. It is to be noted that a servant of that house is not a family member. Then in a suit related to business and work, the agent who is in charge of that business, to that person the summons can be served. Then for a suit of immovable property, agent in charge of that property. In case of suit of immovable property, the agent who is in charge of that immovable property, to that person summons can be served. And if there are 2 or more defendants, and to any one defendant, the summons can be served. The next type is service by court. So if the defendant is residing within the jurisdiction of the court, then the court may send a court officer to serve the summon, or they can do it by a courier, approved courier, or by registered post, speed post, fax message, email, etc. Usually it is sent by registered post. Then if a defendant doesn't reside in jurisdiction, then to that court within whose jurisdiction that defendant resides, and that court will further send a court officer to send a summon to the defendant. And if the defendant refuses to take the summon, then it will be considered as a valid service of summon. Service by plaintiff, Dasti summons. So along with the summons by court, the plaintiff can also take permission of the court to serve the summons by himself. It is called Dasti summon. The plaintiff can directly approach the defendant and serve summons by himself only. It is called Dasti summons. The next type is substituted service. So what if the defendant is nowhere to be found? So if the defendant or agent refuses to sign or defendant absent, then the summons copy is affixed to the door of the house of the defendant or any conspicuous part of the house of the defendant. And if a defendant is purposely trying to avoid the service of the summons, then the summons copy is attached to the courthouse or to the house of the defendant. The next is service by post. So if acknowledgement signed by defendant received by court or defendant refuses or property posted an acknowledgement not received after 30 days, then considered as a summons duly served. So if the defendant accepts the summons and signs the acknowledgement and it is received by the court, then it is considered as a summons duly served by post. Special cases of summons. So if defendant is a public officer or a servant of a railway company or local authority, then summons is served to the head of that department. And if the defendant is a soldier, then to his commanding officer the summons is served. And if the defendant is in prison, then to the person who is officer in charge of that prison. And if the person is of a higher rank, then the summons is served by letter. Case law. Cohen vs. Narsingh Das. In substituted service, proper effort should first be made to find the defendant. So before doing a substituted service, before affixing the summons to the door of the defendant, the postman should make a proper effort first for finding the defendant. The next important concept is payment of interest and costs. So payment of interest, section 34. So what happens in this is the plaintiff is trying to claim a certain amount from the defendant, and for that amount during the pendency of the suit he will take back that claim with interest from the defendant. So how that interest is charged, it is mentioned in section 34. So before suit, as agreed between the parties, whatever the interest the parties have agreed, that the party will have to give to the other party. Pendant light. So from suit to decree, as agreed between the parties, and is unequitable to do so. And for future interest, from the date of decree to the date of payment, the person will be charged with a 6% interest or less. The next is the payment of costs. It is on the discretion of a court. The cost is nothing but the costs incurred by the court. So the parties will have to pay the cost to the court. So we have a compensatory cost. If a claim of a plaintiff or defendant vexatious and disabandoned or withdrawn, then maximum 300 rupees cost will be charged to the parties. They have to pay to the court. And if they cause a delay, then also they will have to pay cost to the court. Next important concept is pleadings. Meaning by Mogha. Pleadings are statements in a writing drawn up and filed by each party to a case, stating what his contentions will be at the trial and giving all such details as his opponents needs to know to prepare his case in answer. So pleadings are nothing but the claims of the plaintiff and defendant. So plaintiff's claim is a plaint which contains cause of action. And defendant's case is defendant claim is a written statement with objections. Case law. Ganesh Trading Co. vs. Mojiram. So pleading meant to give intimation of case to parties and enable a court to frame issues and prevent deviation from a cause of action. The next is fundamentals of pleadings. So pleading should contain facts and not law. It should only contain fact. It should not contain any legal terms, any law. Then it should contain only material facts. So the facts on which plaintiff's cause of action arises and the facts on which the defendant's defense depends, they are called material facts. Facts and not evidence. So there are two kinds of facts: facta probanda, facts required to be proved, and facta probantia, facts by means of which they are to be proved. So facta probanda are the material facts and facta probantia are the evidence. And the pleading should contain only facta probanda and not facta probantia. And next, the pleading should be in a concise form. It should be precise, specific and unambiguous. The next important concept is plaint. So it is contained under Order 7. What is the meaning of plaint? Pleading of the plaintiff containing a cause of action. So it is the pleading of the plaintiff and it contains a cause of action. Contents, Rule 1 to 8. So of course it contains a cause title, name of the court. Then it contains the details of the parties, details of plaintiff and details of defendant. Then it contains a statement if either party minor or unsound. Then it contains a cause of action, jurisdiction of court, then court fees and prayer, then any set of relinquishment of his claim by plaintiff and signature and verification. Rejection of the plaint. So when a plaint will be rejected by a court, so if the non-disclosure of cause of action, if the plaint doesn't contain any cause of action and under a valued relief and plaintiff's failure to correct it, insufficiently stamped papers and plaintiff's failure to correct it, suit is barred by law, plaint not filed in duplicate, plaintiff has not complied with statutory provisions mentioned under Rule 9. Case law, Ruplal vs. Nachattar Singh. Plaint can be rejected as a whole if it does not contain cause of action. A part of plaint can't be rejected. So either a plaint can be accepted as a whole or rejected as a whole. A part of it can't be accepted or rejected. The next is a written statement in Order 8, meaning a pleading of defendant in which he deals with every material facts of plaint, states new facts in his favor or takes legal objection against plaintiff's claim. So it is a pleading of a defendant containing objections to every allegation of the plaintiff in his plaint. Contents. So it also contains the cause title and details of the parties, but the new things here are it contains new facts like not maintainable. This suit is not maintainable. It is a new fact. It is there in written statement. Then next, specific denial of each allegation. So the denial should be specific for each allegation. He cannot say that I reject the plaint. He should take each paragraph and specifically deny it with reasons. The denial should not be vague or evasive, and the allegation not addressed shall be taken as accepted. So if he doesn't address any paragraph in the plaint, then it will be considered as accepted. Distinct grounds set off or counterclaim stated as separately. Case law, Bhadat & Co. vs. East India Trading & Co. If a denial of fact is not specific but evasive, the said fact shall be taken as admitted. The next is set off, Order 8, Rule 6. If a defendant also has claim against plaintiff in suit for a recovery of money, he may claim a set off. So in the same transaction, the defendant also has a certain money to claim from the plaintiff. So he can do that by a set off. So he can claim that in his written statement via a set off. Conditions. The suit must be for a recovery of money. Amount claimed is ascertained sum of money and legally recoverable by defendant from plaintiff, and it should not exceed the pecuniary jurisdiction of the court. Counterclaim. A claim made by defendant in a suit against plaintiff, a cause of action in favor of defendant against a plaintiff. So what happens is counterclaim is along with the plaintiff files a suit against the defendant. So in return the defendant files a counter suit against the plaintiff. It is called counterclaim. So in that the defendant files his own cause of action, and the plaintiff will have to file his written statement to that effect. Judgment pronounced in both plaintiff's claim and counterclaim. So judgment is pronounced in both plaintiff's claim and counterclaim. Both the suit will run concurrently. Then plaintiff has to file a written statement for counterclaim. Even if plaintiff's suit dismissed, the counterclaim will continue. Difference between set-off and counterclaim. Set-off is a defense, while a counterclaim is a cross-action. Set-off must be from the same transaction, while counterclaim can be from different transactions. Set-off acts like a shield to the defendant, while counterclaim acts like a sword to the defendant. Then set-off claim is lesser than or equal to plaintiff's claim, while a counterclaim may be greater than the plaintiff's claim. In set-off, amount recoverable at the date of suit, while in counterclaim, amount recoverable on filing of written statement. Case law, Muhammad Farooq was a state government. The claim for excess amount is always a counterclaim. Parties to the suit, Order 1, Joinder of parties. So what do you mean by joinder of parties? So relief sought is from same transaction, cause of action. When can plaintiffs be joined in one suit? So the CPC allows the joining of parties in one suit. We can either join many plaintiffs in one suit or many defendants in one suit. So when a plaintiff can be joined in a suit, so if the relief is sought is from same transaction, they have same cause of action, and if brought separate suits, so common questions of law or fact would arise. So even if they go for different suit, the question of law and question of fact will be same. So at that time the plaintiffs will be joined in one suit. Joinder of defendants. When will defendants be joined in one suit? So the relief alleged arises out of the same transaction. So the cause of action against all the defendants is same, and if a suit brought separately, common questions of law or fact would arise. Necessary parties and proper parties. So who are necessary parties to the suit? So they have some relief in the same matter. So all the parties, they have some relief from the defendant in the same subject matter, and in absence, the effective degree can't be passed. So the necessary party is necessary for the suit to provide effective degree. Proper parties. So their presence enables court to adjudicate more effectively and completely, but in their absence, degree can be passed effectively. Non-joinder and misjoinder of parties. So non-joinder, what do you mean by non-joinder? If either necessary party or proper party has not been joined as a party to suit, then it is called a non-joinder of party. Whereas in misjoinder, if two or more plaintiff or defendant added to the suit who are neither necessary party nor a proper party to the suit. Effects of non-joinder and misjoinder. The suit is not dismissed and the decree is not set aside. However, if in the non-joinder of a necessary party, the suit is dismissed and the decree is also set aside. Objections must be done at earliest opportunity. Striking out, adding or substituting parties. So if a wrong plaintiff is added, then it can be struck out. If there is a bona fide mistake, and if a defendant added, a plaintiff is amended. Case law Ishwarbhai versus Harihar Behera. So the primary object of joinder of parties is to avoid multiplicity of proceedings and unnecessary expenses. So this concludes second unit.